It's official. Sean Diddy Combs has been denied bail once again. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Okay, so we have some breaking news for you on this emergency sidebar. Sean Diddy Combs will not be reunited with his family in time for Thanksgiving. No, the embattled rapper and music mogul who's been sitting in the Metropolitan Detention Center on federal sex crimes charges since he was arrested in September, he will be sitting there now, what seems to be indefinitely. Why? Because he has just been denied bail by Judge Arun Subramanian. This is the current judge overseeing this case. This judge had not decided this issue yet. He held a hearing on this last week where both sides presented evidence and arguments back and forth for why Sean Combs should or should not be granted bail. And we just got this decision. So I'm going to go through this order by Judge Subramanian right now. It was released right on Thanksgiving Eve, right at the end of the day on Wednesday. It reads, the court has evaluated each of the factors that it must consider under the relevant law. 1, nature and circumstances of the offense charged. 2, weight of the evidence against the person. 3, history and characteristics of the person. And 4, nature and seriousness of the danger that would be posed by the person's release. And it also says that the court has also reviewed the information submitted by Combs and the government across all 3 bail hearings in this case. As you remember, Sean Combs was denied bail both by a magistrate judge and a district court judge. Judge Subramanian writes, the court finds that the government has shown by clear and convincing evidence, so that's the standard, that no condition or combination of conditions will reasonably assure the safety of the community. In support of this finding, the court provides the following reasons. Now, first, Judge Subramanian goes through the allegations in the indictment to show how serious this is. And it reads, the indictment charges Combs with serious and violent crimes. And by the way, we remember he's charged with racketeering conspiracy, sex trafficking, and transportation to engage in prostitution. Subramanian writes, it alleges that for decades, Combs abused, threatened, and coerced women and others around him to fulfill his sexual desires, protect his reputation, and conceal his conduct. To do so, Combs relied on the employees, resources, and influence of the multifaceted business empire that he led and controlled, creating a criminal enterprise whose members and associates engaged in and attempted to engage in, among other crimes, sex trafficking, forced labor, kidnapping, arson, bribery, and obstruction of justice. And it goes on further to talk about more of the allegations. Judge Subramanian writes, the government has presented direct evidence of Combs' violence. And what he cites is the 2016 videotape where Sean Combs is purportedly beating his ex-girlfriend Cassandra Ventura in a hotel hallway. This was published by CNN several months ago. This has been a big piece of evidence in this case. We've talked about it extensively. And remember, Cassandra Ventura is the one who initially filed that lawsuit against Sean Combs back in November of 2023, got the ball rolling with all the other lawsuits and also all the criminal charges. But he not only cites the 2016 video to show his propensity for violence, but text messages between Combs and Victim 1. Now, we believe Victim 1 to be Cassandra Ventura. But it reads, text messages from the hours and days following the 2016 Intercontinental Hotel incident say, I have a black eye and a fat lip. You are sick for thinking it's okay to do what you've done. I still have crazy bruising. From there, Judge Subramanian also says there is evidence supporting a serious risk of witness tampering. For example, Combs initiated and had unexplained communications with Witness 1, who was subpoenaed to testify before the grand jury in June 2024, and in fact testified on July 25th, 2024. Combs was represented by counsel during this time, and they have offered an explanation for some of these communications, but they could not explain them all. For instance, Combs' efforts to call and text Witness 1 even after his grand jury testimony, or Combs deleted texts with this witness. That's bad, right? The idea of reaching out to a witness maybe before you knew they were a grand jury witness, that could be a problem. But really after their grand jury testimony, that's a problem. From there, Judge Subramanian says there is evidence that Combs violated Bureau of Prisons regulations during his pretrial detention to obscure his communications with third parties. We talked about this a lot, how Sean Combs was using other inmates' PAC numbers to make calls, was using a private messaging service to reach out to people, was also engaging in 3-way phone calls. The allegation was he was not only breaking the rules, but he was also doing it to reach out to potential witnesses in the case, maybe to try to influence potential jurors through a social media campaign. campaign. Now, this is interesting because Judge Subramanian writes, the court makes no determination that the content of Combs' communications through these channels was improper. That's interesting. And this is something that he talked about in the hearing about, is it really bad he's posting things or having people post things for him on social media? So he's saying, I'm not really going to focus on the content of the communications, but, and this is something that we talked about in our prior sidebar, it was just the flouting of the rules that was the problem. He writes, however, his willingness to skirt BOP rules in a way that would make it more difficult for his communications to be monitored is strong evidence that the court cannot be reasonably assured as to the sufficiency of any conditions of release, especially given that they occurred when Combs was seeking bail and when he knew the government's concerns about witness tampering and obstruction were front and center. Yeah, really bad that he's doing this when he's already accused of obstruction and he's under the government's eye. But, and this is also interesting, you know another reason why the court was skeptical about Sean Combs being released? And, Judge Subramanian at least kind of entertained what would bail look like, what would pretrial release look like. He went on a back and forth, and we'll talk about this in a minute, where Sean Combs' attorneys had said he has an apartment in New York, there will be private security. Well, here's what the court says. The court doubts the sufficiency of any conditions that place trust in Combs and individuals in his employ, like a private security detail, to follow those conditions. So, wow. So really seems swayed by the prosecution's argument that his private security team could probably be susceptible to manipulation. Now, this part is fascinating. There was a back and forth at the beginning of the hearing, and we're going to get into it in a little bit, where Judge Subramanian was asking Sean Combs' lawyers about a discrepancy. You might recall that there were materials that were photographed from Sean Combs' jail cell. And the allegation was by the defense was that this was a violation of his privilege, that there were materials that were photographed that were subject to attorney-client and work product privilege. And the defense had said that there was a number of legal pads that said legal on top of them. And there was a discrepancy where the judge brought it up about whether these pads actually said legal. He writes, the court further notes that it held an emergency hearing to address the government's usage of notes on legal pads recovered from Combs' bunk. At that hearing, defense counsel advised all these legal pads say legal. Yes, they're marked as legal. After the hearing, the court inquired why, in light of counsel's representation that the notes at issue were on legal pads that were clearly marked as legal, photographs taken during the sweep show no such labels. At the hearing, defense counsel admitted that it has to be the case that as of the day of the search, legal wasn't written on every legal pad, and that they were not sure whether the pad presented to the court had legal on it at the time of the sweep. And Judge Subramanian writes, the circumstances of this incident and the misrepresentation made at the hearing where Combs was present bear on whether the court can be reasonably assured that any conditions it imposes will be followed, or whether through inadvertence or active subversion they will be broken and the community's safety threatened. But as we now know, he's not just facing the criminal charges, he is also facing all these lawsuits, a barrage of civil lawsuits. The floodgates, they really seemingly opened after his ex-girlfriend, Cassandra Ventura, filed that bombshell lawsuit against him, claiming that Combs subjected her to a decade of physical, mental, and sexual abuse. Combs adamantly denied the claims, but you remember he settled that lawsuit with Cassie the very next day, and then there was the surge of lawsuits after that, with several other people coming forward to say that while Combs appeared to be everybody's favorite celebrity rapper, appearing on talk shows, guest starring on TV shows and movies, behind the scenes, they say he was essentially a ruthless criminal. Well, on Tuesday, attorney Tony Busby filed these 5 new complaints, and they share a common theme. They share a common theme with the others that he has filed on behalf of clients who say that Combs abused them. They all talk about Combs' alleged drug use, the claim that he and his associates would drug or lace drinks with GHB or ecstasy that he would give them to unsuspecting victims at parties and auditions. Allegations that not only he, but his associates, his bodyguards, participated in forced sexual acts. And all the plaintiffs, they have filed anonymously against not only Combs, but also his companies like Bad Boy Entertainment, Bad Boy Productions. Now, before I get into this, I have to stress something. Combs has always denied any wrongdoing or criminal activity, okay? He and his attorneys have said that if anything sexual did happen, it was consensual. And remember, he hasn't been found liable in a court of law yet. He hasn't been found guilty in a court of law yet. And I think the argument would be it may seem strange to you and I. You and I might not engage in these kinds of freak-off sessions, but it's not necessarily illegal. Now, the accusations in this first lawsuit, I have to tell you, are so disturbing that there's just some of this complaint I'm not going to get into. That's actually with respect to, I think, the other lawsuits too. Certain details I'm just not going to share, but I do have to talk about certain details. It's important to know what we're saying. It's important to know what the people are saying, why they're saying it, and what the protections are under the law. So with that caveat, let's go into this. Now, one of the latest lawsuits is from a John Doe who lives in Texas. The complaint says, in the late 90s and early 2000s, plaintiff was an actor, regularly traveling across the United States for auditions and roles on stage and screen. After finding out about a role playing a police officer in a music video, plaintiff exchanged phone calls with a female casting director in New York. In October 2001, he traveled to Manhattan to meet with her. Now, we don't know John Doe's age at the time he says he met Sean Combs, but we know that he was an adult. But we've told you about other lawsuits where people claim that when they were children, maybe sometimes when they were auditioning for Sean Combs, they were sexually assaulted. They were drugged. So keep that in mind. But going back to this lawsuit, so John Doe goes to New York. He goes to a hotel near Central Park, and it's there where he meets up with someone appearing to be Sean Combs' bodyguard or an assistant of some kind. And they talk about John Doe's background and his fitness routines. And when Combs comes in, he asks John Doe questions about himself and his trip to New York. And he reportedly wants to know if John Doe is there by himself, meaning did he have any friends in New York? And John Doe told him no. Process that for a second. Because then he says Combs allegedly gave John Doe the once-over and said he'll do. A very ominous statement given what the plaintiff says happened next, because the complaint reads, once plaintiff sat back down, the casting director offered him an alcoholic drink, which he declined. She then offered him a Diet Coke in a glass, which he drank, but noted that it tasted strange. At that point, plaintiff realized the casting director was the only female in the room. The conversation continued regarding the music video and shooting schedule, but as time passed, plaintiff began to feel dizzy and nauseous. He asked to use the bathroom because he felt like he might pass out. And shortly after that, plaintiff did in fact pass out. Based on information and belief, Combs, by himself or through his agents, employees previously, laced plaintiff's drink with drugs, including but not limited to GHB and/or ecstasy. And that theme of alleged drugging is a constant through line in both the criminal allegations and the civil allegations. And we have to warn you that this next part is incredibly tough. The complaint reads, plaintiff came to in a twilight state, still dizzy and nauseous, but semi-conscious and disoriented. As plaintiff tried to get his bearings, he realized he was laying face down across a large ottoman with his head and arms hanging off of one side and the lower half of his body hanging off the other. His pants were pulled down to his ankles and his shirt was pulled over his head. He felt a great deal of pain and realized as he looked back that he was being anally sodomized by Combs. His vision was blurry, but he recognized Combs' chest tattoo and the large gold chain with a jeweled cross on it that Combs wore during the interview. Plaintiff tried to fight him off, but felt dizzy and sick whenever he tried to move. Additionally, Combs' bodyguard was holding plaintiff down by the arms. John Doe then describes further alleged assaults in graphic detail, claiming multiple men raped him that day. He says he could hear other people in the room laughing and talking, believes that he saw camera flashes at one point. And John Doe claims that he passed out multiple times before he was finally able to regain control of his body and get up. The complaint says, embarrassed and violated, plaintiff tried to cover himself up and started looking for his clothes. Once he found his pants, shirt, and shoes, he ran for the door without his underwear and also without one of his prized possessions, a commemorative leather jacket that he got from working as a stuntman on the film RoboCop. Plaintiff never saw that jacket again. As he ran out, he heard someone near the door laugh and say, "Hope you had fun." He goes on to say that the doorman helped plaintiff get a cab and he returned to his room at his hotel, where plaintiff vomited and cried all night, replaying the trauma of what had just happened. He feared others' disbelief and/or the perpetrator's retaliation if he told anyone. In the aftermath of the assault, plaintiff struggled with intense emotional pain and mental health issues, feeling disgusted and deeply depressed. Plaintiff has experienced a significant impact on his personal life. He is never married and often struggles to maintain relationships due to the assault. Now, John Doe is suing under the New York Victims of Gender-Motivated Violence Protection Act. This is something we've talked about before. So even though this alleged assault happened in 2001, John Doe's legal team is arguing that the GMVA would apply in this case, where the requirement that the crime of violence be committed because of gender or on the basis of gender and due at least in part to an animus based on the victim's gender, that is satisfied, they say, because defendant Combs forced plaintiff to engage in a sexual interaction without consent. Now, there is a look-back window to sue for these kinds of claims because when under normal circumstances the statute of limitations would have expired and you can't bring a lawsuit, people can use this now to sue, and they can sue until February 2025. And this protection, by the way, not only allows plaintiffs to recover damages, but they can also recover attorney's fees and costs. That's an advantage here. Now I want to move on to another lawsuit. This one is from a Jane Doe who lives in Maryland now and accuses Sean Combs of sexual assault in 2001. Her complaint states that in 2001, plaintiff, who was 18 years old at the time, and her cousin attended a Halloween party held at Club New Yorker in Manhattan. Combs and his entourage also attended the party and provided drinks to plaintiff and her friends throughout the night. During the Halloween party, one of Combs' security guards escorted plaintiff and two friends to a large black SUV limousine parked within walking distance of the club. They entered the vehicle and saw Combs sitting in the back. At least 6 members of Combs' security team were also in the limousine. One of the men handed plaintiff a drink. Minutes later, she began feeling dizzy, intoxicated, and disoriented. She felt as though she was unable to control her own actions. Based on information and belief, Combs, by himself or through his agents' employees, previously laced the drink with drugs, including but not limited to GHB and/or ecstasy. So you can see similar language here. Combs allegedly ordered her to perform oral sex on one of his security guards, and then she also claims that she was forced to perform oral sex on Combs too. Quote, in the aftermath of the assault, plaintiff struggled with intense emotional pain and mental health issues, feeling disgusted and deeply depressed, with symptoms of post-traumatic stress. And she is also suing for violations of New York City Victims of Gender-Motivated Violence Protection Act. Another Jane Doe says that she was attacked, this time in 2004, also in Manhattan. She says she was a 17-year-old model at the time and went to a modeling gig where she was approached by 2 men who gave her a flyer for a party. The lawsuit says that the party turned out to be one of defendant Combs' infamous 4th of July parties at his estate in the Hamptons. Combs' Hamptons parties regularly attracted A-list celebrities from across the entertainment, fashion, and business worlds, and this one was no different. The event was lavishly decorated, featured live performances, music performances, and boasted top-tier food and beverages, an atmosphere of opulence and luxury full of celebrities. Many unsuspecting individuals like plaintiff were recruited to attend these parties. When plaintiff arrived, Combs' staff at the front door required her to hand over her purse and her cell phone prior to entering. Now, this is something that we've heard before, that guests at Combs' parties had to surrender their phones, and sometimes even it was reported they had to sign non-disclosure agreements before they were allowed in. The complaint continues. Plaintiff recognized numerous celebrities in attendance as she walked around the party. Servers circulated through the rooms of the mansions with trays of drinks, and plaintiff decided to have one. Shortly after drinking it, plaintiff began to feel lightheaded and disoriented. Now, what's alarming about that is if that's true, she just took a random drink and it was potentially laced. I mean, that's the insinuation, right? And that's different than a drink being deliberately handed to her. So again, if true, were all the drinks at this party just laced with drugs? That was my initial impression from this. Quote, as she grew increasingly disoriented, plaintiff searched for a place to sit. She stumbled to a couch and promptly lost consciousness. When she awoke, plaintiff's underwear was missing, and she felt throbbing pains in her private areas, let me just say that. At this point, plaintiff was alone, and she could not find the friend who had accompanied her to the party. In a state of panic, she began to hyperventilate and cry. The complaint goes on to state that Combs and 2 of his bodyguards approached plaintiff and threatened her. Combs told plaintiff that she would be in danger if she spoke about what had occurred, stating that he ran New York and would ruin her. At this point, plaintiff recognized that at least Combs had sexually assaulted her while she was unconscious. She feared for her life. Plaintiff was coerced into agreeing not to contact the police in exchange for the return of her purse and phone. She agreed out of fear of what would happen if she did not. In the aftermath of the assault, plaintiff experienced and continues to experience intense emotional pain and mental health issues, including post-traumatic stress disorder, depression, and anxiety. And Jane Doe also cited the GMVA as her cause of action. Moving on to the fourth new lawsuit, a plaintiff who now lives in Georgia makes claims that he says happened much more recently, 2022, when he was 39 years old. Says he went to a Diddy party at a large home in New York City. He went with friends, drank alcohol that was provided to him, and John Doe says he blacked out. When plaintiff regained consciousness, he was in a dark bedroom with black walls on a bed with black sheets. Everything around him was dark. Plaintiff was horrified to find Combs on top of him, sodomizing him. Plaintiff, in a state of shock and confusion, forcefully fought Combs off and fled the room, making his way to a nearby bathroom. Despite still being in a dazed, disoriented state, plaintiff fled the house in an effort to escape the situation as quickly as possible. He didn't return to the party after the assault, but plaintiff was traumatized by the assault and continues to experience severe emotional distress as a result of what he endured at Combs' hands. John Doe is also filing under the GMVA. But there is something I have to tell you about this lawsuit, and that is that lawsuit was just dismissed. Yes, the judge said that the plaintiff here failed to get the court's permission to file this anonymously as a John Doe. This is an issue we've seen before in other cases against Sean Combs, where courts have said the plaintiffs, they have to reveal their identities if they want this to proceed. Here, it seems to be an issue that this plaintiff never even got permission from the court to do so. So we'll see what happens next. And now this brings us to the fifth lawsuit. And this actually doesn't cite the GMVA as a cause of action. Instead, a Florida John Doe is suing all the plaintiffs for assault and sexual assault. And his lawsuit states, in 2022, plaintiff mingled and spent time with associates of Combs' businesses at a popular Miami nightclub. He did not consume alcohol at the nightclub. After spending some time with these individuals, an associate of Combs invited plaintiff to an after-hours event being hosted by Combs at a residential home. After arriving, plaintiff entered the residence and joined the other partygoers. Plaintiff saw about 45 to 50 people, many of whom were recognizable public figures. While mingling and making small talk with others, an associate of Combs approached plaintiff, indicating that Combs wanted to meet with him. The associate took plaintiff upstairs, where Combs greeted him with a drink and offered a tour of the house. Plaintiff obliged and began following Combs around the home. The tour came to an end in a bedroom. The bedroom smelled strongly of marijuana. 5 other individuals, 3 men, 2 women, apart from Combs and plaintiff, were inside of the room as well. As plaintiff and Combs entered the room, Combs demanded the women perform sexual dances and acts on the other 3 men. Around this time, plaintiff suddenly felt weak and disoriented, unlike anything he had ever experienced with alcohol before. As plaintiff's condition worsened and he began to fall in and out of consciousness, plaintiff knew he had been drugged. John Doe says he passed out, and when he awoke, he was naked, and he says that he saw Combs sexually assaulting him. Plaintiff recalls Combs telling him, "This is what you want," all while wearing, quote, "a disturbing smile." John Doe says that he passed out again, and when he woke up, he was still in the bedroom, but he was alone. Plaintiff woke the next morning in the same bedroom alone, almost immediately, as if someone could see inside of the room through a camera or other device. A member of Combs' security team entered, handed plaintiff his clothes, and instructed him to get dressed and prepare to leave the residence. Now, that's interesting and frightening, because we've heard from various people in these civil lawsuits that Combs had cameras all over his house and was obsessive about filming things. But again, this John Doe is suing for assault and a sexual assault under Florida law. Defending Combs with the assistance and conspiracy of his businesses intentionally or knowingly caused physical contact, including the sexual assault with plaintiff, when defending Combs knew and should have known that plaintiff would regard such contact as offensive. By the way, you sue with the businesses, not just Sean Combs. Obviously, he's very wealthy, but you go after the businesses, they have deeper pockets too. By the way, one of the reasons he might be suing for assault and sexual assault is there might not be a statute of limitations issue. This is just a few years ago. And you also might say these assault claims, taking everything as true, are more straightforward to prove. By the way, speaking of Tony Buzbee, he has gotten himself into a bit of hot water recently. We've talked about this because in prior lawsuits that were filed by him on behalf of alleged victims, he has named people like Celebrity A or Celebrity B, who in one case allegedly participated in assaults. And Buzbee had previously promised that he was going to expose A-list people that were allegedly involved in Combs' criminal activity. But so far that hasn't happened. And an anonymous prominent person says that is because Tony Buzbee is extorting the high-profile people. This person, identified as John Doe, says that Tony Busby is making up false stories about serious crimes like sexual assault and rape, and then threatening to tell the public and file lawsuits if these people don't pay up. It's basically extortion. Settle or you get named. Settle or you get exposed. And there was a lawsuit that was filed in Los Angeles on Monday by this John Doe, and he describes himself as just a high-profile individual who knows P. Diddy, and he's attended events with him. He's being represented by Quinn Emanuel, a very powerful law firm. And the firm released a statement about the lawsuit saying, Busby has established a pattern of leveling baseless, fabricated, and malicious allegations at high-profile individuals and threatening to name them publicly if they fail to pay exorbitant sums of money. Busby then uses this money to fund his lavish lifestyle. He has deployed these threats in letters, statements to the press, his website, and on social media in recent months to try to shake down these well-known individuals. Tony Busby denied the accusations, fired back, saying the lawsuit is just an attempt to stop him from doing his job. And he released a statement to the Houston Chronicle saying these claims are without legal merit, that they're laughable. He said, "We won't allow the powerful and their high-dollar lawyers to intimidate or silence sexual assault survivors. It is obvious that the frivolous lawsuit filed against my firm is an aggressive attempt to intimidate or silence me and ultimately my clients. That effort is a gross miscalculation. I'm a U.S. Marine. I won't be silenced or intimidated." And I actually spoke with former prosecutor Melba Pearson this week about this and how she would fight this if it were her.
It is standard in terms of reaching out and saying, hey, listen, I've been contacted by, someone who is looking to file a lawsuit against you, whatever. Here's where we think we're going. Do you want to settle? Let's settle right now before we even put anyone through this drama, before we have to make the survivor testify, before we have to do depositions and go through the whole process. Maybe we could just settle right off the bat. That's normal, right?
Yeah.
But that fear, and I'm with you on that, Jesse, that fear of I could fight this, but I'm going to lose so much more in the long run, that could be a deterrent and would make someone pay up. But at the same token, I'm hopeful that if you are wrongfully being accused of this, I mean, if it was me, heaven forbid, I think I would go on the offensive and name myself. I would come out and say, listen, I have been, Tony Busby reached out to me saying that so-and-so alleged that I did XYZ to them. I categorically deny it. And basically you come out on the offensive before anything gets filed. So that could maybe deter the case from moving forward, possibly.
And by the way, you can check out that full interview with Melba over on our Law&Crime YouTube channel. Love talking to Melba. She's the best. So for now, it's unclear what impact, if any, these explosive lawsuits will have on Sean Combs' federal case. It's very likely that the government investigators have spoken with these alleged victims, or they will be, as they build their racketeering and sex trafficking case against Sean Combs. Obviously, if there's a superseding indictment, that could all change. If you recall, Burgess went on Banfield on News Nation, and he revealed that he was given 11 flash drives that contain alleged sex tapes involving Combs and celebrities. And he said, of the 8 celebrities on the tapes, those who are victims of Sean Combs, they're not perpetrators, victims, he said 2 or 3 were minors, which, as you know, is consistent with a number of allegations in the civil lawsuits that Sean Combs is currently facing. To be clear, though, Combs is currently not criminally charged with anything with respect to minors. That could change, but right now he's just charged with sex trafficking, racketeering, transportation to engage in prostitution, but all with respect to adult victims. If there's a superseding indictment, he gets hit with new charges, possibly about victims. We shall see. But this is what brings me to what we're talking about right now. So, Mr. Burgess has claimed that he got these flash drives from the late girlfriend of Sean Combs, Kim Porter, who, as we know, tragically died several years back from what authorities concluded was lobar pneumonia. And that is despite the fact that there have been rumors, both online and in the media, that there is something more to her death. And that, to be clear, totally unsubstantiated. That has been debunked. We've talked about it here on Sidebar multiple times. But putting that to the side, here is the other thing with Mr. Burgess. He apparently says he owns the rights to a book that was reportedly based on the alleged memoir of Kim Porter. In fact, according to TMZ, Burgess' phone was seized by the feds, and on it was a copy of a flash drive with material that was used in this book. Here's the problem. Christian and Quincy Combs, these are the sons of Diddy and Kim Porter, Quincy's actually adopted by Diddy. But they are reportedly fighting back, and they have sent Burgess a cease and desist letter to prevent the further sale of this book. They argue this is just an attempt to capitalize on Porter's fame and that they own the rights to her IP, her intellectual property, like her diary entries, her potential manuscript. As her heirs, they own it. And they also want an accounting of current sales of the book. To be clear, though, they aren't acknowledging that there is, in fact, a long-lost memoir from their mother. In fact, they've actually denied that before when there was a similar book, a derivative work, we'll talk about that, published by this guy named Chris Todd on Amazon. They were adamantly fighting against that. They said that their mother wouldn't write this. But what they're basically saying is if something should exist, they own it. Burgess has responded, saying he owns the copyright in the book, that Porter gave him the rights to this manuscript, that the brothers are making, quote, a pathetic attempt, a, quote, desperate ploy to extort him, and this shows how bad their financial situation is, and he reportedly even suggests that Sean Combs is probably behind this. So a lot of back and forth between both sides, and I want to sort it out and at least get one side of the story on this. So with that, I want to bring in Ariel Mitchell. Thank you so much for taking the time. It's great to meet you. So the first question I had when I was reading about this, is this book from your client the same book as the one that was published by Chris Todd a few months ago? That was the one that was on Amazon before it was removed by Amazon. What's the connection there?
Yeah, so Chris did get the book from Courtney. Courtney has a more thorough copy of the book. When Chris published the book that was on Amazon, it was edited. So some of the passages were removed, some of the pictures were removed, and I think there was like a forward or something that was added to the book. So it is a different version, but from the same, what in copyright law is called derivative work. So it derives from that work that Courtney has.
And just to be clear, Courtney's work, Courtney's book, is it currently being sold anywhere?
I'm not exactly sure. I believe Courtney has a, I was about to say, here's a woo-woo, welcome to downtown Miami. But I believe he is selling it on a website. I only came into that knowledge when I received the cease and desist letter from Quincy and Christian.
Got it. And in terms of the content of the book, what is this book about, the one from your client?
So I haven't taken the time to read the book either, but to my understanding, it's Kim Porter's memoir. So it's basically Kim Porter's stories. I haven't read, I shouldn't say that, I haven't read the entire book. I have read several excerpts from the book, several pages from the book. I haven't had time to sit down and read it in its entirety. But to my understanding, it purports to be from Kim Porter about experiences Kim Porter had.
And why do you think Christian and Quincy are so opposed to this coming out? Because they were opposed to the Chris Todd, as you said, derivative work coming out. They opposed to this. What is it about this piece of work that they're so opposed to?
Well, first it's talking about their father. And, you know, for even Quincy, that's his stepfather, but that's really the only father he knows. So, and then Christian, that's his doppelganger. Like Christian and Diddy look exactly alike. So, and then you think about the other piece of it. Their father is the one who gave them money, wealth, fame. So you want to protect that at all costs, even if you know your father did something bad or wrong. I also feel like they don't have any identities without their father. So for their father to go down for this, and what child wants to think this about their parent? Think that their parent was this kind of heinous monster. So I think we have to maybe put ourselves in position how we would feel if this was one of our parents, and what would we do in this situation?
Does this memoir, alleged memoir, does it suggest that Sean Combs was abusive towards Kim Porter? Does it suggest that, does it amplify this message that we've seen online that there's more to Kim Porter's death than meets the eye? I just want to be clear about what this book from your client really says.
So again, I'm going to reiterate, I have not read the entirety of the book.
Okay.
But from what I have read, it does support the allegations that have been made by Cassie, the allegations that have been made by the federal government, and the allegations that have been made by my clients, Tyrone Blackburn's clients, Tony Busby's clients. It's everybody is saying the same thing. And Kim Porter, I feel like we were only willing to hear these things once Cassie came out, and now we are starting to see from Kim Porter's experience that
Right.
these were the exact same experiences.
So the main question that people would have here is, why would Kim Porter give your client this manuscript? What was that relationship? They were close enough where she would give him her memoir, her diary entries. Why would she do that?
So, to my understanding, Courtney was really good friends with Tupac. I'm always trying to explain this. So in New York, we all know the East Coast West Coast beef, right?
Sure, sure.
We all have some knowledge of it. It's only cursory. So you have to imagine on the East Coast, there was two factions. There was the bad boy faction, and then there was Death Row East. So Death Row was starting to encroach upon Diddy's territory in New York. And there are a lot of people in New York who didn't like Diddy, who didn't want to rock with the bad boy East Coast, side of the East Coast, West Coast beef. So there were a bunch of people in New York, a faction who were West Coast, East Coasters, if you will. And Courtney was one of those people. So, to my understanding, Courtney knew Kim through Tupac and Courtney's a industry insider, A&R, or a record exec who brought different people to labels to help them get into the music industry. So he knew producers, managers, all these people in the music industry. And one day he was talking to a friend who was with Kim, and Kim was like, "Who are you talking to?" And he said, "I'm talking to Courtney B." And she said, "Oh, let me talk to him," because they knew each other through Tupac. And said to Courtney, "I got something because for you, I know you'll know what to do with it." And that's the next day is when Courtney got the flash drives, and one of the flash drives had the book on it. So I believe that if we're going to believe, let's say, that Kim really wanted this book to get out, and she knew there were only certain people she can trust because there were more people in Diddy's pocket than were not in Diddy's pocket. Why wouldn't you go to his enemy, Diddy's enemy, which is people with the Tupac faction? And if you really want this information to get out, because anybody else is not going to get that information because their loyalty will always lie to Diddy. So I think, just me using my brain and the information I have been given and my understanding just culturally about what is going on, because it's my culture, it makes sense to me how Courtney ended up with this.
You don't anticipate that this is going to escalate into some sort of lawsuit and this going to court? And it sounds like if it is, you're ready to fight back against it.
Not only fight back, we're ready to countersue for defamation and other things, other torts. But I wish I would invite them. If you're watching this, please, I beg of you, please sue us. That'll be the best day of my life and the worst mistake you'll ever make.
Why is the issue of Kim Porter and this book and Courtney maybe trying to publish it, why is that coming out now?
Well, I think what initially happened was when the book was first published on Amazon by Chris Todd.
Right.
So that kind of created, it was number one for weeks on Amazon, actually, number one bestseller.
Yep.
To my understanding, at the last count, sold almost like 20, 30,000 copies in that range. So it was really selling. So then there was a time where Chris was doing all these interviews, and then there was something going on behind the scenes because I had known Chris since August. That's when I initially met Chris, and I didn't meet Courtney until 2 days before on the 31st. I didn't meet him until October 29th. So I didn't know who he was. Chris did represent the entire time, even with the book, because we did start talking about. First, he came to me like, "Oh, I have some information that may be relevant to the cases you have against Diddy," and that kind of morphed into, "Well, we have this stuff. We don't know what to do or how to use it. Can we get some legal advice or direction? And I'm like, we don't want to tread on extortion, just kind of trying to get an understanding for what they had and what they understood. But Chris never told me about Courtney. He told me he had a partner, but never told me who Courtney was. And then all of a sudden one day I see Chris is doing interviews about the book. And I'm like, oh, okay. And then shortly thereafter, I get a call from Courtney saying that he just was served with a summons by the federal government. And then I went back and saw an interview that Courtney had done on October 20th, where he is now stepping out of the shadows, saying that he's the one who had the tapes, he was the one who had the book, and that's how all of this came out. And I feel that that interview Courtney did October 20th is what led to the summons from and the subpoena from the federal government, because now if he's saying he has all of these things, he's now, and I think something no one is keeping in mind, we've seen all of these victims file civil lawsuits, right? But why hasn't the government called them as witnesses before the grand jury, right? You would think those would be people that would be called.
Do you know for sure? Do you know for sure they haven't?
Well, I don't, to my understanding, at least none of my clients have been called.
Sure,
and
fair enough.
I know other lawyers, and I've talked to them, and none of their, at least I'll say this, none of their clients who already have active lawsuits have been called. Now, there might be some other people who have been called, but those people are not plaintiffs in a civil litigation. However, with Courtney doesn't have a lawsuit against Diddy. He's not a victim of Diddy. So I think the other part of this is being an unbiased third party. So the government is really the credibility that they felt that he had and the information that they believed him to have based on what he said in an interview on October 20th. They issued a summons for him 4 days later. They issued a summons for him in a subpoena October 24th, and they didn't serve it to him till October 28th. And then I talked to him October 29th, and then we went to the grand jury testimony on the 31st. So that was like the progression of those things. But I think it's just a culmination of the government is trying to look for all relevant information, people who purport to have relevant information, especially people who can't come across as untainted because they don't have a bias. And, every civil litigant does have a bias in seeing him go to jail. We all want to see him go to jail, not only for the benefits of our cases, but because our clients were really injured. And the ultimate penalty is having your freedom taken away. But Mr. Burgess isn't somebody who's unbiased. So I really feel like between his unbiased perspective and what he purported to say he had, I know, and it also relates to what I said as well, because we had a separate hearing and the prosecutors brought up what I said in my interview as well.
By the way, what is, if you can tell us, do you any plans for him to come back to the grand jury to testify?
No, we were able to waive and close our testimony.
So in other words, what they wanted from him, they have at this point.
They have.
Combs has been trying left and right to make bail, to get out of there. And he has already been denied bail and pretrial release by multiple judges. But here's the thing. This Friday, and we're going to cover this here on Law and Crime, he is set to make his argument once again, but this time in front of a new judge, Judge Arun Subramanian. So this is the new judge overseeing this case. This is a judge who hasn't heard the bail issue before. And we have already seen briefs back and forth from the prosecution and the defense about why Combs should or should not get bail. But that brings me to what the prosecution alleged most recently, and we did a sidebar about this, because they claim that while behind bars, not only are prosecutors continuing to investigate Combs and presenting evidence to a grand jury for possibly a new superseding indictment with potentially more charges, but they have been actively monitoring him. And they say that Sean Combs has not only broken the jail rules, but he is possibly engaged in obstruction in this case. And therefore, he can't be allowed out on home confinement. So in their most recent filing, the government writes, the government's grand jury investigation of the defendant, including the defendant's obstruction related to this criminal case, is continuing. As part of that investigation, the government has sent grand jury subpoenas and document requests to the Bureau of Prisons, the BOP, for the defendant's monitored communications, including calls and emails. From those materials, the government has learned that the defendant has persisted in engaging in obstructive conduct since he entered BOP custody. Among other things, the defendant has engaged in unauthorized communications practices, including three-way calling on the monitored phone lines, use of other inmates' phone access code or PAC numbers to make phone calls on the monitored phone line, and use of a third-party text messaging provider through the BOP's monitored email system. Each of these methods of communications is prohibited by BOP. Furthermore, as set out in the government's November 15, 2024 brief, the defendant used these unauthorized methods of communications to continue to engage in obstruction, including by instructing third parties to reach out to witnesses and attempting to influence the jury pool in this criminal case. Now look, prosecutors, they previously cited as an example this call from October 4th where apparently he's speaking from jail to one of his adult sons, and while the content of that call is redacted, the government said that this is a clear inference that his goal is to blackmail victims and witnesses into silence. They also say that he enlisted his family to create a social media campaign around his birthday where a video was posted online of them wishing him happy birthday over the phone. You actually hear him on the other line. Again, this is when he's behind bars at the MDC. And prosecutors say this was done to influence a potential jury pool. But they also say they have evidence that Combs may have paid off a potential witness. Now, how do they know that? Well, they explain that there were notes recovered from his jail cell during a widespread sweep of the MDC. And that is the issue. And we've talked about this before, but the MDC is a mess. It is plagued with violence. It is plagued with smuggling. And so there was a raid. And prosecutors explained that back on October 28th, the Bureau of Prisons and other agencies swept the MDC. This was pre-planned. It was done to ensure the safety and security of staff and inmates. This wasn't just focused specifically on Sean Combs, but multiple housing units were searched and electronics were found, homemade weapons were found, other contraband was found, but they did search Combs' bunk. And prosecutors indicate that, look, they were aware in advance that the sweep was happening, and they were aware that Combs' cell would be searched, but the prosecutors made clear they were not part of this search. This was the Bureau of Prisons. But prosecutors admit that they are now in possession of potentially privileged materials, meaning attorney-client or work product materials. But they say, don't worry, these already went through a filter team before they came to us, so to make sure there's no privilege issues. By the way, when we're talking about privilege, attorney-client privilege are those private conversations between a client and a lawyer about representation, about the case. And work product are materials made in anticipation or preparation of trial. And generally speaking, both can't be used by the other side of trial. Well, the defense, as you can imagine, was not too happy about this. So they wrote in a filing, defense counsel has recently learned that the prosecutors are in possession of attorney-client privilege material, including the defendant's own written notes. This search and seizure are in violation of Mr. Combs' 4th, 5th, and 6th Amendment rights. Moreover, the targeted seizure of a pretrial detainee's work product and privileged materials created in preparation for trial is outrageous government conduct amounting to a substantive due process violation. Because the prosecutors are currently in possession of privileged material and are actively using this material to detain the defendant, the defense requests an immediate evidentiary hearing. And yes, the judge ordered this emergency hearing. This was yesterday. This is what we're going to talk about in a little bit. But just to give you an idea of what we're focusing on here, this was the prosecution's argument. They said they did nothing wrong. As I mentioned, they said, look, we weren't part of the sweep at the jail. There was this investigator from the Bureau of Prisons who was there. He interviewed Sean Combs about contraband, and he found in Combs' bunk or on Combs' bunk a manila folder marked legal, another notebook, an address book, and some personal effects of Sean Combs. He ended up taking photos of the notebook and the address book, but he didn't take anything. But to be clear, since a lot of this is redacted, we don't really know exactly what the contents of this notebook were, but this investigator alerted prosecutors that he took photos, and he said that the notebook was about Combs' notes to himself. Now, prosecutors said, okay, we want to be completely safe on this. Send all of the photos to a filter team, make sure there's no privileged materials. After that filter team reviewed, they sent certain photos to the prosecution team, and the government admits, yes, we used these photos of Sean Combs' notebooks in our motion to oppose his bail. We used it. For example, there was evidence from these photos to prove that he had paid a potential witness. And they argue that despite the defense's claims, this wasn't a targeted seizure of the defendant, and the photographs didn't violate Sean Combs' constitutional rights. The defense, they responded in their own filing. They wrote, "The government's letter only reinforces the fact that the government has committed an egregious, willful, and harmful breach of the attorney-client privilege and has become privy to defendants and defense counsel's trial strategy, including areas of expert testimony, witness strategy, and other confidential matters." They say this investigator actually took photos of more materials than the prosecution claims, namely that he took photos of several legal pads. And the defense says that of the 19 pages the prosecution had sent over to them, these kind of photographs that were recovered, 11 of them are Sean Combs' notes to his lawyers, actual conversations about trial preparation and bail. His defense team writes, on top of his legal pads and notes, he has a folder marked legal. This is to put anyone on notice that everything along with the folder marked legal is exactly what it says. Legal attorney-client materials that he brings to his meetings with his lawyers to prepare his investigative and his trial strategy. Two different arguments, two different sides. Now we have this hearing from yesterday to get to the bottom of what happened. Now, to be clear, this is what we do now. There's no cameras in the courtroom, unfortunately, so we're doing our best to report to you about what happened. It was reported that Sean Combs appeared in court, that he was wearing a tan olive jumpsuit, similar to the one that he wore last time, maybe the same one he wore last time. The judge actually, by the way, granted the defense's request for Combs to be unshackled too, maybe even for the future proceedings as well. And from there, the arguments began. Again, no cameras in the courtroom, electronic devices are limited, so this is the best recap we can do based on the reporting. So Combs' lawyer, Mark Agnifilo, told the court that he believes that this sweep of the MDC was actually a pretext to target Sean Combs. He explained that this is a clear violation of Sean Combs' constitutional rights, that he has an expectation of privacy in his legal notes. Few things, by the way. Let's talk about this. So he is correct. A criminal defendant does have privacy rights in privileged documents, conversations, materials. In terms of a Fourth Amendment right against unreasonable search and seizures, that privacy right, that is limited in a detention context because those rights can be trumped if there are issues with maintaining security and order at a jail or prison. But Mark Agnifilo also reportedly says he wants the surveillance video of the search. He wants the communications about the investigator. He wants to know the role of the United States Attorney's Office, who said what to whom, whether there was even a violation of Sean Combs' Fifth Amendment rights. And that deals with self-incrimination, but more specifically due process rights, how the government can't take away your life, liberty, or property without due process of law. And get this, Agnifilo says this is so bad, this is so egregious, he may ask that this whole indictment be dismissed. Or he may ask that the prosecutors have to recuse themselves. By the way, you might be saying, that seems not like it's ever going to happen. That seems nuts. Go back and watch what happened to Alec Baldwin in his manslaughter case. The prosecutors withheld evidence in that case. The judge was so angry at this violation, she threw the whole case out. Anyway, from there, going back to Judge Subramanian, he turned to the prosecutors and he said, what's going on here? What happened? To respond to that, we had U.S. Attorney Christy Slavic. And she reportedly said that the 19 pages from Combs are about paying off a witness and finding dirt on victims. That's not privileged material. A little bit of a side primer here on that. So materials that are about ongoing or future crimes are really not protected by privilege. But she also emphasized that her team had no contact with the Bureau of Prisons or this investigator. They didn't even know that the investigator was going to be part of this sweep. She claims that their team only found out about these photographs after the sweep, not like they directed this to happen. Now, the judge apparently pressed her on how this investigator was monitoring Combs in his communications and asked if what had happened is a Fourth Amendment violation. Slavic said, yes, he provided us materials, but this investigator, he doesn't work for us. He works for the Bureau of Prisons. He's focused on safety. And if the defendant was in compliance with Bureau of Prison rules, which she says he was not. Judge Subramanian asked if there was any other material that was photographed here that they should be talking about. And Slavic indicated she didn't know what else the filter team may have. So you're seeing that separation between the prosecutors and this filter team. By the way, we don't know exactly who this filter team is, but again, this filter team. There was also this interesting reported exchange where Judge Subramanian asked Prosecutor Slavic along the lines of, is it standard procedure to photograph notebooks rather than take them so it could be known they were taken? To which AUSA Slavic apparently responded, I don't know. But Slavic reportedly doubled down, saying they don't have to tell the defense of an ongoing investigation into Sean Combs. And plus, we sent the materials to the filter team. If there was a privilege issue, they would have caught it. To which Subramanian reportedly asked if these were verbatim notes of Combs meeting with his lawyers, how would you know that unless you ask the defense? To which Slavic says they rely on the work of the filter team. They trust them. So Judge Subramanian expressed what seemed to be concern at this dividing line between a covert investigation and discovery. What needs to be turned over? What needs to be told to the other side? Since Sean Combs has already been charged. And Slavic reportedly responded, we have an ongoing grand jury investigation for conduct that Sean Combs has not currently been charged with. And there's no authority that we have to tell them what is going on. And this was another interesting back and forth between Judge Subramanian and Prosecutor Slavic, where he asked, is any of this material privileged? And Slavic seemed to respond that the notebook was labeled things to do, not attorney-client. And as to the claim that the papers were supposed to be in the folder marked legal, she said self-labeling is not enough, especially when they say this is about action items involving non-lawyers. There's no privilege here, like it's stuff about family members and birthdays and financial advisors and inspirational quotes that it has nothing to do with the case at all. So Judge Subramanian also asked, would prosecutors be willing to turn over that surveillance video of the search to the defense? To which Slavic said they are opposed to doing that. And it was interesting because at one point, the judge apparently said to Mark Agnifilo how prosecutors kind of want to work with the defense to resolve this issue. And reportedly, Agnifilo didn't seem too keen on that, reportedly said, we don't want to give them any insight. And he fired back too, Mark Agnifilo. He said all the legal pads here, they say legal. That the photos taken were from pads marked legal, that the government isn't being accurate about what happened here, that everything in these pads are things we discuss with our client, trial strategy, who we should speak to. Everything is about the racketeering case, that Sean Combs' to-do list, that is privileged, that this is the heart of attorney-client privilege. Mark Agnifilo said virtually every single thing in these legal pads are matters he discusses with his attorneys. And he called this whole seizure a complete institutional failure. Now, in the end, here's what the judge decided to do. He told prosecutors, get rid of the copies of the 19 pages of material. Get rid of them. And he wants copies sent to him, too, so he can see what's going on. And he also indicated that prosecutors will not be able to use that evidence when they argue against Sean Combs' bail this upcoming Friday. That's a blow to them. That's a blow to their case. And by the way, as I mentioned, there is going to be a hearing on Friday regarding bail. We will cover it here on Law&Crime. Now, in terms of whether there were potential privilege issues, whether there were privilege violations, he's not ready to make a decision on that. Wants both sides to prepare arguments, briefs, and then he'll decide that at a later date. But it seems that the filter team can still keep the notes at issue as long as they are not part of the prosecution's case, as long as they're not part of prosecuting Sean Combs. They have to be separate. Now, I do have to leave you with one final tidbit from this hearing. Came at the very end, but so important. So the judge, in regarding bail, again, which is going to be talked about on Friday, he asked about the Mike Jeffries case out of the Eastern District of New York. This is something we covered here on Sidebar. This is the former head of Abercrombie who was arrested and charged with sex trafficking recently. He was arrested and charged after Sean Combs was released. And he was released on $10 million bail. Sean Combs' attorneys made that argument. Why is it fair he gets out and not our client? And you know what Judge Subramanian said? He advised the prosecutors, be prepared to explain that difference between that case and this. So that is a slight opening for Sean Combs that he may have a legitimate argument for why he should be entitled to pretrial release, especially when he has put forward a bail package of $50 million, home confinement, 24/7 monitoring, and so forth. So you couple that with the fact that prosecutors can't now use some of that evidence from the jail in their arguments in opposition to bail. That's a slight win for Sean Combs. He has a better shot maybe for bail, but we'll see what happens Friday. That's all we have for you right now here on Sidebar, everybody. Thank you so much for joining us. And as always, please subscribe on Apple Podcasts, Spotify, YouTube, wherever you get your podcasts. I'm Jesse Weber. Speak to you next time.